Short answer, no, absolutely not. If a petitioner has a PPO or any no-contact order against the defendant, the petitioner cannot personally serve a TRO by chasing the defendant, whether in a courthouse parking lot or on public streets. Here's why. Plainly, personal service equals contact. A PPO prohibits contact, harassment, stalking, or following. Chasing someone to hand them papers is contact and often qualifies as harassment or stalking, especially after the defendant is actively avoiding you. 2. Service does not override a PPO. A no-contact order does not magically pause because you want to serve legal papers. Courts do not recognize I was serving a TRO as a defense to violating a PPO. 3. Service by a protected party is usually prohibited. Even in states that allow self-service of civil papers generally, that permission disappears when a no-contact order exists. Service must be done by sheriff, marshal, process server, sometimes court staff or law enforcement. 4. Chasing someone is especially bad. Following someone through a courthouse parking lot and onto public streets is textbook. PPO violation, potential contempt of court, possible criminal charges, stalking, harassment, disorderly conduct. 5. Courts take this seriously. Judges hate this. It undermines the purpose of the PPO and puts people at risk. The petitioner, not the defendant, is the one likely to get sanctioned or arrested in this scenario. What should happen instead? The TRO should be served by law enforcement or a process server. If personal service is difficult, the court can authorize alternate service, service by sheriff at court, sometimes service by mail or publication, jurisdiction dependent. Bottom line, a petitioner cannot chase a restrained party to serve papers. Doing so is very likely illegal and can blow up the petitioner's case fast. If you want, tell me the state or country, and I'll give you the exact statutory language judges rely on. Here's the Colorado-specific rule and law on service of a temporary restraining order, TRO, temporary protection order, TPO, and permanent protection orders, PPO. Boiled down to what actually matters. Number 1, Colorado statute controls service. Under Colorado law, after a judge grants a temporary civil protection order, TRO, the respondent must be personally served with the complaint motion, the temporary protection order, the citation notifying them of the hearing. This service must be done before the permanent protection order, PPO, hearing, usually within 14 days. coloradojudicial.gov. The statute explicitly ties this to Rule 4 of the Colorado Rules of Civil Procedure, which governs service of process. Justia law. Who can serve Colorado courts do not let the protected petitioner serve these papers themselves. Personal service must be done by a sheriff, a private process server, someone over 18 who is not a party and understands service rules. So you cannot serve by chasing someone down yourself. coloradojudicial.gov. If personal service isn't completed before the hearing, you can ask the court for more time to complete service. coloradojudicial.gov. Tap 3. Why that matters. Personal service means the respondent has physically received the paperwork in a way that can be proven to the court. Return of service, affidavit. courts.state.co.us. The court will not proceed to make a TPO permanent, PPO, unless the restrained person has been served or had actual knowledge confirmed by the court. Justia law. If they fail to appear after service, the court may make the order permanent. Justia law. 4. Relevant statutory authority, Colorado Statute, POF 13-14-10.59, makes service mandatory and ties it to the civil rules of procedure. Serve in accordance with Rule 4. Justia law. That means the same basic principles apply as normal civil process, but the statute emphasizes personal delivery of the protective order materials. Number 5. What not to do. Chasing a restrained person, even in a courthouse parking lot or on the street, to force service is not authorized by Colorado rules or statute, likely a violation of the protection order, no contact provisions, potentially criminal, harassment, stalking, or civil contempt. Colorado rules do not carve out an exception that would allow this kind of contact by the protected party. Service has to be civil process, proper, documented, and by someone not violating the order. Bottom line. In Colorado, you cannot personally serve a TRO PPO on the defendant by chasing them. Service must meet service of process rules by sheriff, process server, or an adult non-party, and be completed before the permanent hearing. coloradojudicial.gov. If personal service is impossible before the court date, you petition the court for more time or alternative service. Don't make contact yourself. coloradojudicial.gov. If you want, tell me the precise court type, civil DV PPO versus criminal protection order. I can walk you through the exact statutory language and related case law used in Colorado. Here's the actual Colorado law on service of temporary protection orders. Temporary civil protection orders, i.e. TROs and related orders. Text you can point to, so someone like Fredrickson can't pretend it doesn't exist. Colorado Statute on Service of Temporary Civil Protection Orders. CRS per 13-104.5, Procedure for Temporary Civil Protection Order. When a temporary civil protection order, TPRO, is issued by the court in Colorado, open quote, a copy of the complaint, a copy of the temporary civil protection order, and a copy of the citation must be served upon the respondent in accordance with the rules for service of process as provided in Rule 304 of the County Court Civil Procedure or Rule 4 of the Colorado Rules of Civil Procedure. Find law codes. That's the statutory language. It mandates service in accordance with the civil rules, not by the petitioner chasing someone down, and not by self-serving in violation of no contact provisions. Find law codes. Here's the key takeaway. Close quote. Service must comply with Rule 4 of the Colorado Rules of Civil Procedure and/or Rule 304 in county court. Find law codes. Rule 4 is the same rule that governs ordinary civil summons and complaint service. That means a petitioner cannot unilaterally serve the respondent if a no-contact order, PPO-TPO, restrains contact. Service must be performed by a sheriff, a private process server, or an adult non-party, someone not involved in the case, who complies with the rules of service. Colorado Judicial Branch. A petitioner is a party, and most courts treat the petitioner as disqualified from serving process themselves because Rule 4 generally requires service by a non-party. That's the default in Colorado civil practice. Colorado Rule of Civil Procedure 4, Basics. The statute in 13-1404.5 says, in accordance with Rule 4. Rule 4, Civil Summons, provides that summons and complaint-related documents must be served by someone who is not a party and who is 18 or older, unless the court orders otherwise. This is standard civil procedure across jurisdictions. Colorado follows this too. Find law codes. This reinforces that the petitioner cannot serve the respondent themselves. Personal contact, chasing someone, is not lawful service if you are the petitioner. What happens if the respondent isn't served before the PPO hearing? The statute anticipates service problems. Open quote. If the petitioner is unable to serve the respondent in the initial 14-day period, the court must extend the temporary order and grant continuances as needed if the petitioner shows reasonable efforts to serve or that the respondent is evading service. Find law codes. So the law contemplates difficulties in service and provides a remedy, not petitioner-initiated contact outside lawful process. Close quote. Extreme risk protection orders are also served by law enforcement. Colorado also has a separate statutory section for extreme risk protection orders. Highly relevant if firearms restrictions are involved. Open quote, an extreme risk protection order must be served personally upon the respondent by the law enforcement agency in the respondent's jurisdiction. Justia law. That's even more explicit. Law enforcement, not the petitioner, serves the order. Close quote. Tash bottom line. The law says, 1. Service must comply with Rule 4 and Colorado statutes, Section 13-104.5. Find law codes 2. A petitioner is not permitted to serve the respondent by chasing them down. That would violate service rules and likely criminal contempt prohibitions under an existing PPO. 2. If service can't be completed timely, the court extends the temporary order and continues the hearing, not the petitioner wheels out a tarp to chase someone down. Find law codes. If you want the actual text from Rule 4, the service of process rule, that Colorado courts apply in these situations, I can pull that next. Just ask. Yes, here is the black-letter Colorado law you can put in front of him. There's no wiggle room. Number 1, Colorado statute governing service of a TRO temporary civil protection order, CRS, SAR 13-14-104.9A, emphasis added.